Sudhir, I have to point out. Original 2-year law degree courses became 3 years. They said, why now have a training again or an exam again? But
possibly even underlying pinning could be
in relation to member of
how it would work out.
Can you imagine? So Prabhakaran will have one set of
means the
rules in his bar.
consisting of all the members of that
The other states will have their own set of rules.
Mr. Mishra and Mr. Prabhakaran will have the same set of rules.
Therefore, if the political party is the larger set,
That's true.
then the legislature party
So
is the
They have
subset
had meeting of mind on many issues.
Yes,
of
and
members of that political
that
party who
will
are
not
also be elected.
is taken
And
care
now
of.
are the
This power is left
It is quite possible that
India.
you can have a political
Fixed
party
body.
or legislature.
They prescribe the power, all of them implement it, and there is one uniform. Otherwise, it would have been
Legislature party is a subset of
21, 24, 1B. So it got deleted for some other reason.
That is every member.
There is strong logic behind it.
Every member of the legislature party will necessarily be a member.
We will, in the 3-pager mention this uniformity, because this
Now,
but
coming to the role,
Well, revising it.
here,
secondly, para 15. In the light of the submissions made in the headings
Suppose there is
immediately preceding the
case
present
of
heading,
split
court's
in the
rejection
House.
of the nexus between
I am
Article
asking
1 and 49 based on the
As a
fact
general
that Bar
principle of
Council
law,
of India had
what
no
is the
role
role of
to play in
Suppose there is a
imposing pre-enrollment conditions does not hold water.
And the matter is
The Bar Council of India is clearly entrusted with the rule
Does
making
it
power to
stand-
prescribe those
does it
persons
stop-
that are entitled to be enrolled. It is humbly submitted. The 24(1) of the Act and its opening words would make the section and the conditions leading up
When do we
to
avoid
attaining the right to be enrolled subject to the rule making
Generally
power
avoid
of 49 of the Act.
When they-
Thirdly, it is submitted that even
When the
assuming that the
jurisdiction
Act
is
prior to the amendment of
Typically, there is
1973
a higher
had
form
empowered the
of the
State
law
Bar Council to prescribe
And
training and
generally,
examination.
is subordinate
It does
to
not
the
take away the power that is vested in the Bar Council of India under 49 of the Act.
And they
Humbly submitted that the legislature is not expected to have any superfluous provision that the Lordship will not construe any provision as OTOs or locations. But specifically empower the Bar Council of India with this specific action regarding pre-enrollment training and examination with the purport of 49. Though the words used are to a classes or category of person entitled to be enrolled. While construing that, your Lordship will grant it those incidental and
I'm saying classes and categories will include the prerequisites to be so enrolled.
requisites as part of the incidental power.
Therefore, you can prescribe the pre. That's how I understand it.
Yes, as part of the incidental power. And there are case law on incidental and ancillary power under the rules of construction. We have cited it.
Second point
And some English cases which have reiterated it. Whether you don't readily infer ultra vires.
Is
You start with the
legislature
presumption even in
members
subordinate legislation that it is intra
Any
vires.
legislation, you will try to see that it is sustained as long as it is sustainable.
In substantive law, your Lordship will say constitutionality. Here, it's intra vires. There, your Lordship will grant all the power because everything cannot be specified. So you grant the power and that will encompass, it will envelope within itself such of those accidental ancillary to further the objects of the Act.
Would really
not
relate
something
to
alien to the Act.
membership
We are
of
only
that
trying to improve the
house.
standard.
That's what when
Who is entitled to enroll? They say you now take
Or,
this exam.
the case
That
may
will
be
not,
one
cannot be,
person.
and not Mr. Rahul who appealed for the Bar Council. Canvas this, 49.
anything about your political
Your Lordship will see from Sudhir. Not that will not, this
Very
is all.
agnostic on
Yes, what we are
legislature because
Our canvas
uh,
will not in
that is irrespective of whether there is or
Nine.
not this qualification.
Which I had mentioned that political party may not have any member of.
Fourthly, it is submitted that while assuming that the Amendment Act of
What we are concerned
1973
Now,
did take
the
away the express power
what
vested
I
in
call
the
the
Act for
structure
holding
of
of pre-enrollment training, it
First,
will
one
still
is
not
definition.
take away the
Who is the
overarching
substantive
rule-making power
qualification?
that is vested in
Three
the
and
Bar
four
Council
are
of India in
exemptions
this
that
regard.
disqualification.
Context may be given
One
to the
third
introduction of an
member,
examination in the
so
very act
who
of
is
repeal of the same. In the All India Bar Committee of 1953 recommended that the uniform minimum qualification for admission to the role of advocate should be a law degree of at least 2 years of study, at least. Of law followed by 1 year apprentice course in practical subjects, followed by examination in these subjects. Lord, we have put the Attorney General's compilation. Because the Attorney General was gracious enough to make his compilation available yesterday to us. The functions recommended for the state bar councils by the committee also read as follows. Power to provide and make arrangements for imparting legal education, holding examination and training of advocates under the directions of All India Bar Council. There is a very interesting passage.
I'm trying to say that the
Early pages of
fields
the
are
note. I
completely
just
different.
digress a bit and go there for this reason. Page 6.
Becomes 218. If
Page
person
5, your
voluntarily
lordship.
given up his membership, number one,
Something, my lord, which
it
is a
absolutely common
practical
sense
insight
that if
to
a
this.
person is given up his sense, he's not going to
Keep
find an
your lordship
application
may
in
continue with 26, but just digress and go to page
People
5
who
of
come
the
for the
law.
symbols order are saying, look, we are in this party, the rival group is in
While
this
the
party.
Advocates
Please
Act
decide
of
who the real party.
1961 was yet to
2-1
be
is
tabled in
your-
the parliament,
What is 2-1?
the Law Commission of India in the 14th
Violated the
report on reform of
So
judicial
the role of
administration
disqualification is
sought to
basically
endorse
the person who
the
gets
views of the
elected
All
on
India
the
Bar Committee and further
Then
provided
keep the party
insight into the
government.
considerations that
Then you
led
get
to the need for a
only
central
point
legislation
that
for
the
advocates.
issue of giving up
Committee
the
noted that every
membership
student of law
political
must,
party
after a
with the meaning
2-year
of
study in
2-1A
university,
Yes.
have a
is
practical
not
course in
confined
law
to your
to be imparted by the
activities
Bar
within the
Council.
Yes.
Thereafter, in the context of law, examination should be conducted at the end of the practical course. The report stated the following, because of significance even today. We have already recommended, that is the Attorney General's
is not
communication, not
confined
page
to what
107
you do
at
within the
110.
folds of the house.
We
Unlike
have already
2-1B,
recommended the
which
division
is
of legal
votes or
training
abstains
into
from
2
voting
years
in the
training
house.
in the principles and
But
theory of
2-1A
law
is
to be
my
imparted
daughter.
in full-time institutions and the
Voluntarily
years
gives up
practical
membership
training to be
of-
imparted under the direction of a body of professional men. At the end of the university training of 2 years, the law graduate will have
Is
to
not
decide
therefore
whether he
confined
wishes
to
to
what takes
embark on
place
an
within the
academic
fold of
career
the
to
house.
research in law or a professional career
Is
to a
also
practical
saying,
training in
What
law.
is the meaning of
A practical training is as
There are
essential to the
judgments
making of a
If
professional
one
lawyer
particular member of
as
party
through
X
academic training,
has
as a
attended
thorough
all the
academic
meetings of
training. The
party
matter
Y.
has to
He has
picturesquely
participated
put in the
in the
following
council
words
of
by a
party
writer.
Then has he
All
given
the
up his
theory
party?
in the
So
world
the exam
equips
is
the lawyer
yes,
with all the legal lore at his fingertips,
But that's
but doesn't know how to draw a summons, a will, a deed, or a bill of sale. Law schools furnish their graduates with new, shiny, potent tools. Unfortunately, the average graduate has little knowledge of how to use them as a 2-year-old child has of
He
how to
attended
use
the
a
rallies of the
blowtorch.
party. He attended the
Perhaps
meetings
Chief
of the
Justice
party. You were
Vanderbilt,
seen in this
at
particular
graduates of this
The
kind
Supreme
in
Court has
mind,
said,
you observe
no,
that
the name
law
is still
schools should be
continuing the register
concerned not
for
only with the
4 years.
principles of law,
In two
but with
cases,
the
they
know-how
said,
of
since
putting the
we
principles
indicated
to
that he
work.
given up
Law
his
schools of the country
So,
cannot
is it a-
continue to lag behind the engineering and scientific schools with their laboratory work or the medical
But
colleges
what
with
is
their
the
clinics.
But one
It is
thing
not
is
right
that,
that young lawyers should learn the skills
2-1A
required in
as
the
well as
profession at the
2-1B
expense
is
of their
members
ethics.
specific.
He members.
But I'm sure Mr. Mishra will
It's not
work
in
out
that
an
sense
arrangement
members
for the
specific.
training
It's the faction
without prejudicing
as to
the
whether a
trainees
particular faction
and allowing
represents
them
the
to fend for them.
No, but
There used to be a 2 years law course,
collective
proficiency.
group
It's called proficiency. It's 1 year proficiency, 2 years law course.
Yes.
And your
So
also
now
is
what
right,
is the
in
thing
the
is-
early 60s, I understand not
Para
your
15
pay
basically
to join a
collective
leading
rightness, the collective
former
party, who is the
solicitors,
real party. And
pay the other.
That dynamics has completely changed. Dynamics,
para
as
15
Mr. Gopal said, that it's not the force of last refuge.
And if lordship,
In-
and
for
lordship
many,
has
it's
seen
the
Sati very
force of
several
the
times,
first
I would repeat.
instruction.
But the first paragraphs are very interesting. How did this problem straight away
And
come?
there are law colleges
Because
have
Nijalinga
day
party,
zero
the Congress, so
where
Jagjeevan Ram was
placement
Congress, they were
what
all
happens,
gone through the controversy.
and then
Those days,
the- they are picked up.
etc.
all the national
then
schools have more
the
than
argument
60, 70
was
students in every
That the
batch being
Congress were
picked up to
majority, the
run
Congress working committee.
we got by
But can you
corporate
just-
handling
your problem
litigation.
is that is this
That's
big,
valid of which year,
law
actually?
1975.
53,
75.
page
But is this
26,
linked
and we come back to 26.
69.
Yes.
We were, so in that sense,
So we are still analyzing about the scheme of the act.
a postmortem.
Thereafter,
No, but
the 14th report of the Law Commission of India on reform of judicial administration.
Normally,
Commission specifically approved a 2-year study at a university followed by a practical course in the law, which will then be followed by an examination. The specific context requiring an examination and training as a power specifically vested with the State Bar Council is that university education was to be for 2 years, followed by a specific 1-year training and examination to further equip a graduate with the skills required to be an advocate. This can be read as part of the intention to have a thorough legal education for candidates, given the yearly structure that was proposed for the candidates. Therefore, in this background and conflict that the State Bar Council were vested with the power to prescribe pre-enrollment training and examination, submitted that in this light, the review in the year 1973 is also to be considered. The requirement for a 1-year training and examination in order to equip a graduate with the skills while he was still part of the education system was found to be necessary due to the 3-year law course introduction as a consequence of the power of the State Bar Council.
And the All India
Then, my lord, having considered the context in which the above mentioned examination was to be conducted, humbly submitted that this examination was specifically brought into the Act to be part of the legal education curriculum of a candidate having found to be unnecessary based on its linkage to the duration of the course, would not in any manner restrict the overarching power of the Bar Council under 49(1)(a)(g), my lord, which empowers the prescription of a condition that would entitle. The lordship can not stick because that point is made. 24 capital A is misplaced, my lord, because that is power to disqualify a person from enrollment. It's materially different from prescribing condition, my lord. This is Majumdar adverts to this clause to say that it is not even part of 24A that a person who has not taken the exam would be disqualified.
Then evidence
Then we are on now. Incidental and ancillary power, we are kindly come to
I am humbly submitting
Para
that
57.
nothing to do with the bench.
There can be no quarrel with the proposition emerging from the judgment in Sudhir in view of the opening words of 49(1) reads, Bar Council of India may make such rules for discharging functions under this Act. Your Lordships have always held that the opening words in a rule-making clause have its own, potency and power as long as it is for discharge of function. The enumeration is only illustrative. Kindly see 49(1). 49(1).
Lordship, see page 44 of R4's compilation.
When you say
Only
in
one.
particular or including the following, the opening words belong
2nd July 22.
all encompassing. As long as the rule is enacted for
Yes.
furthering the object of the Act. The Bar Council of India may make rules for discharging its functions under this Act.
Document number 9.
What is it? What
It's
is
in the
it?
Sadiq Ali
Bar
compilation.
Council of India
It is
may make rules for discharging its functions. The power of enrollment is not to the Bar Council of India.
Compilation of documents
Power
and rules.
Power of enrollment
This
is
is
to
document
the
number
state
9.
bar council.
What is
Yes.
it? 22nd.
22nd.
Power to fix the criteria.
Correct. That is something different.
Eight
But power of
number?
enrollment,
That is state for normal enrollment is not.
the power to enroll is with the state bar council.
We have got
And that may be the
total
reason
118 page.
why they had
Yes.
said initially that the power of training and examination will be with the state
The
bar council.
notice is sent to both.
Now,
And
in
then
that light,
subjects also.
now
After the preamble,
read
and
the
into paragraph.
powers.
Now, beloved.
The commission is in receipt of communications and
In particular, such
is
rules
also
may
member of
prescribe.
parliament.
Kindly come to A.
On 25/6/22 intimated the commission.
Shall I place the entire
about the alleged anti-party act.
No, that's fine.
The class or category of person entitled to be enrolled as such. That is below so.
Using the name.
While it is true
Chusena or
that
Malasai.
The only way to
And
accept your
also
submission is
order 3 letters dated.
to give an expanded
And
motion to AG. When we give the class
So further
or
immediate-
category of persons entitled to be enrolled as advocate,
there is a legal principle why I'm saying.
your,
Eknath Shinde.
correct me if I'm, what I'm rephrasing what
While
you are
the
saying.
petition before the commission.
There,
titled as
this
so-and-so
expression,
with
class
the
or category of persons,
symbols, to
would
declare the group led by
include the
Eknath
class and
Shinde
category of
and not
persons
the party
who have
symbol of
cleared
word
the
after the group.
pre-bar
Eknath
exam.
Shinde's above petition.
This is what I-
And then he goes on to one.
And there is a legitimate legal jurisprudential basis which comes to the next.
Just
But this
one
is
more
the
thing.
standard
You see,
format we file whenever we get a.
ultimately,
You
if
say,
you hold that your right
what is
to
the gist of this
practice
complaint? What is the other side? Please come to paragraph.
depends upon your clearing the bar
Paragraph
exam,
15 of the election symbols.
Whether it's
Reservation Allotment Order 1960 provide that the
pre-enrollment
commission is satisfied.
or
Information your lordship seeks
post-pre-enrollment,
are visited. On due consideration. of
ultimately
the
functions
totality of
and performs the same or
With the commission as summarized above.
Except post enrollment, the 30,000, the way I have dealt with it.
that will
One
examine.
But pre-enrollment will not.
And the other.
What your lordship says.
Your submission is the
Each
direct
group
and
is
simplest
nominated
method
by the
is
party
to
and
provide a
matter is
pre-enrollment
standard
examination.
determination by the commission.
To obviate all
Paragraph
these
15 of the
possibilities.
election symbols.
And therefore,
Order
if
to
the
take
expression
over
issued here in 49
Protect their rights and interests.
are taken
And
to
going by the
include
past
while
precedents, the commission has directed the
Enrollment.
documents
then that would
submitted by the
subside.
rival groups, the exchange.
How do we invoke any principle to include that? You know,
The
kindly
steps
see
envisaged
the
in
further
the
panchayat.
paragraph 15 proceeding. Prior to the hearing, rival groups.
I'll read page 28, paragraph 58,
The respective documents.
and then will not come to
Of
this
the support claimed by them.
doctrine of incidental and ancillary powers. A well-known rule of construction
Both the group furnished
in administrative law.
the respective documents. to
However,
support their claims by
Page 28, paragraph 58. In applying this
When the
principle
matter
to the
came up
Advocates
before
Act,
the court,
this
this is just the
way
first
to
step.
consider the
You need to
BCA's
stop.
rules could be
Then all the
traced to the
inquiry
BCA's function
But
of exercising general supervision and control over state bar councils under clause G of 7(1) of the Act. There is also this power, that 7(1), when it deals with the function for the Bar Council of India, it says supervision and control. 6 deals with functions of the Bar Council of the state. Functions of Bar Council of India. 7(1)G shall be to exercise general supervision and control over state bar council.
By submitting this application, by respective sides,
Suggesting to my
none of
lord
the provisions
that
of 10 schedule are
we have
retroactive.
to do an overall reading of the Act. If the object of the Act sees specific provisions, then we will see whether this and category give a legitimate basis for construing that the Bar Council of India can prescribe an all India bar
Para
exam.
15 is like, say, inner party democracy. Suppose
Well, kindly
as
come
a
back
party
to
goes,
28.
bound to be groups, bound to be factions, and ultimately who claims superiority? There is no floor to test the house.
Line about
The
3.
only election can do is
Secondly,
document.
this honorable court has been
Listen to the party.
interpreting 7 of the Act as a provision
Now, what
which
is just how
exhaustively
you
lists
have
the
done it?
BCA's statutory functions.
Anna DM.
Why do I say so? Because 7 will not, before we also do away with 7.
No, what I'm saying is, because you actually see the House of Parliament. And
Do all other things necessary for
not
discharge.
impact the functioning of the election.
Perform all other functions
Two
conferred
things
on
are
it
happening. Either or should allow the
by or under this Act, by the Act,
result of the
Lordship knows,
order will be completely
by the
independent
provisions
of that.
themselves.
Whether
But
a
under
person
the
is
Act, will
qualified
also
or not
include
qualified. He doesn't cease to be a member of the.
the rule making
party.
will not done.
And we have to go by the majority of the.
Kindly come back to 28, Milord.
Not of the legislature.
Thirdly, it is submitted that an additional
Party, but not of the political.
Yes. Thank you, sir. Yes, sir.
AG में ले आ रहे हैं ना
Well, if my arrangement is right, these two, 10 schedule and para 15 operate in different schedules. Then he's right. That's what your lordships have to decide. My lord made a very important and significant comment. A lot of these issues in respect of voluntarily giving up members of the party doesn't happen in the House. You go to Gujarat, hobnob with the opposition. Then you go to Guwahati. From there, you are sending notices. Then you accompany the leadership of the BJP to the governor. All this is not within the House. All this is outside the House. And the speaker will have to consider, for the purposes of coming to the conclusion, whether you are voluntarily giving up membership of the party, not the House. It is because of that you are disqualified in the House. Giving up membership of the party outside the House amounts to disqualification within the House. So you can't say one is different from the other. What happens in the House is unrelated to what happens outside the House. The election commission can't say, I'm not concerned with any of that. Number 2, Manoj, in paragraph 2(1)(b), if you vote against the whip, you will be disqualified not just under 2(1)(b, but also under 2(1)(a). Once you violate the whip, Manoj, not only have you expressed yourself that you are voting contrary to the whip, you are also saying, I'm no longer a member of your party, but I'm not bound by your whip. That's the constitutional position. With the greatest respect to my learned friends, Manoj, they are completely misled, Manoj, the decision of this court in Rajendra Singh Ram. Let me just give you a notice briefly what it was. Of the BSP. joined hands with the Samajwadi. Now, there were 109 members of the House. The Speaker gave notice, nothing. He did nothing. After a few weeks, 24 more of them joined. So they became 37. Then the Speaker said, this 37 is 1/3. And because this 37 is 1/3, therefore they are protected under the 10th schedule, because at that time paragraph 3 was there. This court said no. You have to decide on the day when 13 members went to the Speaker. But at that time, not 1/3. The Speaker wrongly allowed 1/3 to develop to give protection to the 10th schedule under paragraph. Therefore, the disqualification relates back to the time when the 13 members of the court speak. That's one part of it. My limit is completely right. This can't relate to the issue of giving up.
We have a special bench at 4:45.
Pressing tomorrow.
Continue tomorrow.
Wait for this. When paragraph 3 was before it was deleted, very interesting. It is integrally linked to the political party. And we see our compilation statutes.
दोबारा जाके वाला है ना
You can read it out.
Sorry. He says not given to the court. Sorry.
That's okay. And it's not in the footnotes. Otherwise, normally it's in the footnotes.
Yeah.
कल मैं आनंद को कल सुना जाएगा देखा
The footnote doesn't have
लेकिन मैं
I'm sorry. Where a member of a house makes a claim that he and any other members of his legislature party constitute the group representing a faction.
Why should you
And they see whether the coordination of
now 2 मिनट सुन लेंगे
this
हमको वैसे
Who is appearing in this article?
which has arisen as a result of a split in the original political party.
you might be making a mention tomorrow
150 of their companies. Better with the
May just ask that your lordship to submit.
And such group consists of not less than 1/3 of the members
Whenever
of such
Lordship,
legislature
that turn
party.
comes tomorrow after.
He shall not be
You
disqualified.
are, I take it, are you opposing free?
So what does it say? A member of a house should claim that he and any other members of his legislature party constitute the group representing a faction
We're not
which has
opposing
arisen in the
a pre-enrollment bar exam.
You are okay with pre-enrollment?
Yes, your lordship.
That's fine.
Yes, your lordship.
So when the speaker decides with the paragraph.
Actually, I think everybody is saying pre-enrollment. Is there somebody opposing even pre-enrollment?
Merely because you make a claim is not enough. The speaker will have to prima facie decide.
We Sudhir will not, because we Sudhir is directly on this point.
We are considering, yes, that's why the opposition bench is considering we should.
It's not a question.
Therefore,
of
we
the
take it
legislature.
that everybody is admitted that
And
pre-enrollment
that is the
exam.
case with this paragraph
Which can only
37.
happen if we
36
modulate
and
to that.
37.
Just certain points with regard to the pre-enrollment exam.
Essentially 37 for the last while.
You point out if we want to listen to you on something.
Yeah.
If you are supporting pre-enrollment exam, there is no point in duplication of
This
argument.
is
Is your stand something contrary to what has been argued till now?
74 SCC.
Say
Malaya.
yes or no, for you to decide, not for us to
In
decide.
their compilation is 192.
Okay.
Then you will have to see what that partly is for us to.
I'm reading 36 and 37. 192 minutes probably.
Thank you.
219, my lords. It's 219, they are quoting Jagjeet Singh Miller's paragraph 69, the lords. My lord, just, it's in italics. Not in italics, but in intention. My lords have that. Apart from the above, the acceptance of the contention that only a claim is to be made to satisfy the requirements of paragraph 3 can lead to absurd consequences, besides the elementary principle that whoever makes a claim has to establish it. It will also mean that when a claim as to a split is made by a member before the speaker, so as to take benefit of paragraph 3, the speaker, without being satisfied even prima facie about the genuineness and bona fides of the claim, has to accept it. The It will also mean that even by raising a frivolous claim of split of original political party, a member can be said to have satisfied the stipulation of paragraph 3. The acceptance of such a broad proposition would defeat the object of defection law, namely to deal with the evil of political defection sternly. We are of the view that for the purposes of paragraph 3, mere making of claim is not sufficient. Prima facie proof of such a split is necessary to be produced before the speaker so as to satisfy him when such split has taken place. This is contrary to what my learned friend argued, completely contrary. Now see 37. Thus, in the above decision, it has been clarified that it is not enough that the claim is made to have split in the original political party, in addition to showing that 1/3 of the members of the legislative party have come out of the party, but it is necessary to prove it at least prima facie. Those who have left the party will have prima facie to show by relevant materials that there has been a split in the original political party. And my learned friend argued that no, in Rajendra Singh Rana, they have said we are the original political party is not concerned with the split in the legislature. It's just the contrary. The argument, therefore, that all of the 37 MLAs required to do so was to make a claim before the speaker that there has been a split in the original political party and to show that 1/3 of the members of the legislative party have come out and they need not produce any material in support of the split in the original political party cannot be accepted. The argument that the ratio of the decision and Judge Singh revised to be reconsidered does not appeal to us. Even going by Ravi Naik, it could not be said that the learned judges have held that a mere claim in that behalf is enough. Now, what's important here, and this is the significant part. Having done away with paragraph 3, now consider the consequence. Now there is no question of majority minority. There is no question of 1/3, 2/3. You have to abide by the discipline, and the only defense is paragraph 4. To say, therefore, the whole argument is that I am 40 or I am 30 or I am 20 is neither here nor there. For the purposes of the 10th schedule, this is irrelevant. So what has happened is, I am the party, I am the Shiv Sena. I am recognized by the Speaker of the Shiv Sena. You are members of the original political party who are represented in the House. You have done an act contrary to, in collaboration with others belonging to the opposition party, done acts which amount to voluntarily giving up membership of that party. Now, if this is decided by the Speaker in these petitions, what will it relate back to? Relate back to what happened after 21st of June. Paragraph 34 of this judgment clause. The act of disqualification occurs when a member voluntarily giving up his membership of the political party or at the point of defiance of the way wished to him. Therefore, the act that constitutes disqualification in terms of paragraph 2 is the act of giving up or defiance of the whip. The fact that the decision in that regard may be taken in the case of voluntarily giving up by the Speaker at a subsequent point in time cannot and does not postpone the incurrence of disqualification by the act of the legislature. It will therefore relate back. If it relates back to us, then it will relate back to what happened between the 21st of June and thereafter. What the Election Commission is seeking to do is to decide the status of the party, so-called party, on 19th of July. But what will happen on the 19th of July thereafter has nothing to do with what's happened before. Because what has happened before is that they have given up the membership of the party. Let's ask the question, a very important question that we threw him out of the post. But let's see our head. Volume 2. First, we show the letter to the Election Commission. Now, let us kindly see the letter we wrote to Cindy on the 30th of June. It was much before 19th July. At page 321. Convenience compilation, volume 2, page 321.
Yes, Mr.
Dear Mr. Shinde, you have been indulging in anti-party activities and have also voluntarily given up membership of Shiv Sena. Therefore, in exercise of powers vested in me as the Shiv Sena Paksh Pramukh, I remove you from the post of Shiv Sena leader in the party organization. So, Malas, I tell him that you have already by wax given up membership of the party. So it's not a question, Malas, of removing him from the post. Now see the letter we write to the commission. At page 333. This is on the 1st of July.
Yes.
Second paragraph. As you are aware, Eknath Shinde has indulged in anti-party activities and has voluntarily given up.
1488.
1488.
PDF.
As you are aware, Shri Eknath Shinde has indulged in anti-party activities and has voluntarily given up membership of Shiv Sena. Consequently, he was removed from the position of Shiv Sena leader in the party organization set up by Shiv Sena Paksh Pramukh Shri Uddhav Thackeray in terms of party. Just to mention that he was not an elected member in the party organization. He was nominated by the leader. Uddhav Thackeray is the president of the party from 1990 to 1923. I still remain the president of the party. The now. 2018 to 2023. As per the records of the election commission. So I remove him. He was a nominated member. I remove him. I tell the commission and I tell him that you have voluntarily given up membership of the party. So it is my case, Malas, that he is not even a primary member of the party. Not by virtue of the fact that I have thrown him out. By virtue of the fact that under the 10th schedule, he has committed acts in terms of which he is disqualified by virtue of 218. My learned friends are saying that this has nothing to do with the election commission. As a matter of constitutional law, how is that possible? In other words, the election commission will decide and will presume as a matter of law that he continues to be a member of the party. Whereas this under the 10th schedule, by his acts, he is no longer a member of the party. So, Manas, how is that possible to say that no, these are two different cycles? others. And therefore, Madan, I'm saying because there is no defense now available under the 10th schedule at all as far as paragraph 3 is concerned or any other paragraph is concerned. The only defense available is merger. And in the context of merger, Madans, if your lordship looks at paragraph 4, just give me a minute. Very interesting. Should not be disqualified under subparagraph 1 of paragraph 2, where a regional political party merges with another political party. And he claims that he and any other members of the original political party have become members of some other political party. So, Madas, if he is a member of the Shiv Sena and Shiv Sena merges with somebody else, the stand of Shiv Sena is effaced. He is no longer Shiv Sena. He merges with another party, or he has another party merge with him and he forms a new party. The new party or the merged party becomes his original political party. I hope I made myself clear.
Yeah.
So it becomes his original political party, so he's washed his hands off the Shiv Sena. That's the consequence of paragraph 4. Then he can't maintain a petition under paragraph 15. Because he's either merged or he's formed a new political party. And those who are left behind, that is, who are less than 1/3, because 2/3 makes for us, those belong to the original political party. In this case, Malad, us, of course, in the absence of a merger. So, therefore, the nomenclature of the original political party, which was attracted when they were first elected to the House, they've lost that in the paragraph. Now, see what my learned friend read. He said, please read the last part. For the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of the House shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. Naturally, because we are now talking about formation of a new party. Therefore, you are no longer the original political party. This will take a bit of time.
Mr. Sibal, you can conclude your argument.
No, you are the joint council.
They have argued for
No, that cannot be tit for. No, that cannot be tit for tat that he has taken 2 hours.
Cited certain fragments further which I
All right, you can, Mr. Sibal, you can deal with the judgments. You can tell us what the point of distinction, what we've been noting along is you go along and what the point of difference is.
I have no problem. I can finish it then. Now, therefore, now let's come to paragraph D.
Paragraph D of?
Okay. Our Mr. my colleague Maninder Singh cited paragraph D of our petition.
Okay, the ground. Ground.
Oh, yes, the grounds. What your prayers.
What I was saying is there are certain judgments that have been cited that are wholly inapplicable. I just want to point out that there are 2 other judgments. It's all right. Read the whole paragraph.
No,
Let's read the whole paragraph.
Ground D of ground page 8, right?
Because and children By which time he is voted. That's the point, Manoj.
But that will be considered, Mr. Council, at the time when we consider the question of disqualification.
But if you lordship allow the election commission to go on and vote, and that's the point, Manoj. Either your lordship says one has nothing to do with the other, and if your lordship is saying you will consider it at that time, that means that has something to do with the other. I'm not saying, I'm only saying, Manoj, these are great repercussions. Because in this situation, then X number of people of a political party who are in power can be named away. Governor will give them votes, and we'll go to the election commission and say, you declare us the simple words, and it's political. That's the consequence, which is sought to be prevented by taking away the third paragraph 3 of the 10th schedule. The whole purpose of taking away paragraph 3 is let's not have any splits. Then paragraph 36 minutes. Also read it half of it. I'll just read that minutes. Page 10. The contents of paragraph 24 to 32 are denied. It is submitted that merely claiming the support of a majority of SSLP cannot be looked at in isolation. If the delinquents were so keen on a change in party leadership, they ought to have approached the election commission in the very first place itself, having committed a series of anti-party activities culminating in the blatant violation of Whip 3.7 as well as of 4.7, and having read the writing on the wall as to their imminent disqualification from membership of the assembly, the splinter group has now rushed to the election commission to claim that they are the real Shiv Sena. This is what they did. They did it on the 19th of July, knowing full well that the writing is on the wall. Then, my learned friend cited two other judgments. There was Kerala judgment where there was no disqualification.
2021 4 23 said at page 50. But he didn't read it out.
Let's see Palani Swami, what does he cite?
Palani Swami.
Well, that is a pure issue of why the matter was pending before the commission. I myself argued it. The question is, who should the symbol go to, or should it be frozen? Interim symbol, which has nothing to do with the tension. Rani Swami had nothing to do with the tension. Matter was pending before the commission. There were rival claims. And the question was, who should get in the interim symbol? What has that got to do with this issue? The third judgment my learned friend cited is the Kerala judgment. So that my colleague.
That Mr. Jetmalani
cited.
He didn't cite.
Paragraph 4,
He really just gave us a citation. He has no doubt.
No, he said that this is the first time the court is decided.
Page 51.
Yes, now I just note paragraph 6 of that judgment says, the learned single judge has also failed to appreciate the fact that even when the writ petitioners claim that rival groups exist in the party and their group is the party, no petition under the 10th schedule has been preferred. It's not a case of the 10th schedule at all. Para 6 at page 172, 3 minutes. Para 6.
At page 173.
Yes. It's not a case of any application also for disqualifications. Then he cited Kanhaiyalal Gomar. Now, Kanhaiyalal Gomar, brothers, it is a writ petition challenging the power of the commission under the symbol law. The violence of the symbol law. What has that got to do with disqualification? That's Kanhaiyalal. As well as all party Hill's leaders conference, brothers. That was a case. The election commission is a tribunal for the purposes of 136 before 1985.
Yes.
Now let's kindly see what the notice of the commission is to us. Page 701. Compilation Miller's document, volume 2. Kindly see paragraph 4 on due consideration. This is their notice. You also have that? That is 701.
That is document number 9.
Yeah, on due consideration of the totality of information available on record to the Commission, as summarized above, the Commission is of the opinion that there are two rival groups in Shiv Sena party. So he's already assumed. There are rival groups in Shiv Sena when the whole question is whether he's a part of Shiv Sena or not. One led by Uddhav Thackeray and the other led by Eknath Shinde. So you assume this, Malad, on what basis do you assume this? And each group is now claiming the party. That's not my claim. I am saying he's no longer in the party, he's voluntarily given up. How does he, on what basis does the election commission come to that? Assume that fact. Matters require substantive. Now see next paragraph. In order to place both the rival groups on even keel, but this is very strange. Both the rival groups on even keel. Where does he get that from? So what the election commission is doing is, I don't care what's happening under the 10th schedule. I'm not bothered what's happening under the 10th schedule. Even if you are deemed to be disqualified, even if you are voluntarily given up membership of the party, I will treat you on an even keel. I will assume you are still a member of the party. Whereas he can't, the election commission can't assume that. We have already written to the election commission that look, he is no longer a member of the party. He is voluntarily given up. So on what basis does he say not even keel? And to protect their rights and interests and going by the past precedent, Commission has directed that the documents submitted by the rival group be exchanged and reply given then. Then was interesting. The steps envisaged under paragraph 15 prior to hearing of two rival groups or others, if any, inter alia require both rival groups to submit their respective documentary evidence to support claimed by them in the organizational and legislative wings of the party. Now that's very important. So three elements in these notices, which according to me are completely contrary to the record. And they are aware of my letter, at paragraph 2, 2A. Sorry, 2B. Anil Desai by email forwarded 3 letters whereby it was mentioned that the following members have been judged in anti-party activities and have voluntarily given up membership of the party. Now, Commission can't decide that issue. So now let's go back to the last part, 702 that I was reading. Support claimed by them in organizational and legislative ways. Well, let's just pause here for a minute. Just reflect on what happened. The 30th of June, they were all sitting outside. There was no organizational wing. They were in Guwahati. They were sending letters from Guwahati that I throw you out, I am the person, I am the chief whip. Gogavli is the chief whip. Your person. Where was the organization? There was no organization. There was no activity in the organization. Evidence of support claimed by them in the organization. There was no support claimed by them in the organization until the 30th of June. Even after that, there was no support. It only comes later. Secondly, on the legislative wing, your lordship knows that the judgment said that has to be considered. Now, if the legislative wing, according to us, all 40 of them, are deemed to be disqualified, well, how will the election commission consider it on an even keel by virtue of proceeding under paragraph 15? The very foundation of it is lacking. You are presuming a foundation which doesn't exist. You are presuming that they are members of the Shiv Sena when they are voluntarily resigned. I have informed you about it. And you say we will treat it as an even keel. Now, nobody disputes whether a big argument is made about 324. Nobody disputes that power. Who disputes the plenary power of the election commission? Not I. We're talking about the interrelationship between proceedings under the 10th schedule and proceedings before the election commission to decide on symbols when one impacts the other. And the priority is whoever started proceedings first will be given priority in terms of decision making. If it is an afterthought, then after everything has happened and you have voluntarily given up membership of the party and thrown out an elected government, then you go to the election commission on the 19th of July and say, I am the party mother. Certainly the election commission can't get precedence. Now, as far as plenary power is concerned, and this is the last point I wish to make. Paragraph 15 deals with an admitted position that we are all members of the same party. That's how paragraph 15 came into existence in 1968. There was no question of 10th schedule. There was no question of election. And what used to happen, the history of litigation in this area would have shown that every faction used to throw out membership, members of the other faction. And obviously, election commission could not decide those issues. So they say, okay, let both factions come and we'll see who has the support. But that the foundation of that went away the moment the 10th schedule came. Then the question of factions didn't arise. Then the question of disqualification came. The purpose being that those who are disqualified cannot get the symbol of the party. Because they have voluntarily given up membership of the party. Otherwise, why have that? Why we had 2-1 at all? If it is only a question of the legislature, argument was this all relates to the legislature, that relates to the party. But then why have 2-1 at all? So paragraph 15 presupposes legitimacy in the context of membership of the party and two factions arising out of legitimate membership claiming to be that party. That is paragraph 15. Paragraph 15 doesn't allow the election commission to disregard what has happened under the 10th schedule. Because if it does, what will happen is, supposing your lordships decide in my favor, let's assume your lordship will decide in my favor ultimately in the petition, what will happen? They will say, we are the party. Now what's left in this matter? Turn the clock back. Election commission has decided. So it makes my petition infectious. If our lordship decide against me and say no, what happened was perfectly legal, in any case they will get the symbol. So they are not in any case prejudiced. Why is it that we want this to go on today? When your lordship will decide this matter in October, here the matter decided. What is the great urgency today that this must go before the election commission so that the other season freezes the symbol or gives it to somebody without having this matter decided? And then they say, look, my speaker is there, my speaker will decide. Well, how will the speaker decide? Because this court has said on the 29th of June that everything that has happened after 29th of June is subject to the orders of the court. They must have glossed over. So how will the speaker decide that issue? And then the larger question is whether when they go to the deputy speaker that you are disqualified because we have moved a notice of removal against you. The speaker said this hasn't come from any source at all. It has come from an email that I'm not even aware of. And it is rejected. And that fact is suppressed when they come to this court. And what's interesting is this course, and I'm sorry, I'm taking time, I didn't want to take too much time to watch it. Let's see what the order on the 27th. Then show me careful. It says, meanwhile, as an intent, sorry, Yeah.
What is the date of the order?
Date is the 27th of June.
PDF 2151.
2151.
Compilation of orders and pleadings is there in page C, Madhus.
Thanks. Yeah.
Meanwhile, as an interim measure, because it's about a few paragraphs.
Yes, we've got that.
On
Yes,
page 3.
meanwhile, as an interim measure, the time granted by the Deputy Speaker of the Assembly to the petitioners or other similarly placed members of the Legislative Assembly to submit their written submissions up to today by 5:30 is extended to 12/7/2022. Correct, Madhus? Now see your Koholo. Para 110. The argument is he gave us 2 days time. He gave us 2 days time. Natural justice. That's the argument. Therefore, this court extended it. Now let's see the order. See pure Koholo. Para 110. Order is in the teeth of 5 the constitutional bench of this court. The government was cooperating. Then we came to court that look, the consequences of this is the government will topple. Then the just intentment of the status of the repository of the adjudicatory power, Speaker, Chairman, judicial review. Prior to the making of a decision by the Speaker, Chairman, and a legitimate action would not be permissible, nor would it be permissible at an interlocutory stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceeding. And such disqualification or suspension is likely to have grave, immediate, and irreversible repercussions and consequences. There is no power to interdict the proceedings. It is only after the decision is taken that you can challenge it. That's the constitutional judgment. So where is the question of coming to court and saying you gave me only 2 days notice? Wait for the decision of the Speaker, you challenge it. The result was, because the court extended it for X number of days, the government toppled. And then we came to court and said, we said, in fact, I remember I told the court that this is what's going to happen tomorrow, which is simple, why do you worry? We have passed an order saying everything is subject. Now they are saying it doesn't matter. And what is this inner party democracy? I have not understood. Inner party democracy in the context of 10th schedule means what? That you can topple any government you want to topple by joining hands with the opposition. It has no difference. It makes no difference. Inner party democracy is in the context where you are continuing to be a member of the party, not doing anti-party activity, and air your grievances within the forum of the party. Inner party democracy doesn't mean that you violate the 10th schedule and say I have the right to violate it. And this is inner party democracy that's been given up. This concept of inner party democracy by violating the 10th schedule, not going to the organization, staying in Ahmedabad and Guwahati, doing acts outside the house, and then going to the election commission on 19th of July when you've done what you had done and joined hands and formed government and will become a chief minister. And then you say that, look, as far as I am concerned, the election commission will now decide whether in fact if this is the law. I think it bodes ill for the future of elected governments in this country. That's exactly it.
Thank you, Mr. Yes, Mr. Yes, Dr. Sangeeta.
I'll give it in point form. What is the crux of the case? For the nature of the phrase voluntarily giving up membership of the party. Whereas in actual practice, 90 if not 95% of acts or omissions coming under 2(1)(a) relate to activities outside the house. By the very nature, 50 examples out of hundreds. Going and was bashing the party or abusing it outside. Going to a rival party and accompanying them for a topic. Indeed, going to the governor with a rival faction. Now, all of these have nothing to do with what you are doing inside the house. Voting or not voting in a trust board, voting or not doing this, etc. A very important judgment of your lordships had occasion to consider it. I'm going to only 5 minutes. Ravi Nayak. Before I cited the book, out 1994, supplementary to SCC 641. Ravi Nayak was said that, and this is practical, no person comes and says, I have defected. While it's being given to your lordships, kindly appreciate the nuance of this clause. Nobody ever said, there is no case that says, I have done anti-party activities or I have defected.
He says speaker can infer.
The infer, word is infer. The operative word on which Ravi Nayak is based is, it is inferred A and B by conduct. That's the heart of the principle. Just read para 11. Just that. Now, this I will read to save time from the middle. All of 11 is important, but just read that middle brackets. Middle of para 11, my lord. The said paragraph provides for disqualification of a member. They are talking of 2 members of a house belonging to a political party. If he has voluntarily given up his membership of such political party, unquote. The words voluntarily given up his membership are not synonymous with resignation and have a wider connotation. Now, kindly read this. This is what I am relying on, but it's coming now. A person may voluntarily give up his membership of a political party, even though he has not tendered his resignation from the membership of that party. Even in the absence of a formal resignation from membership, and inference, the operative word, can be drawn from the conduct, that's the second operative word, conduct, of a member that he has voluntarily given up the membership of the political party to which he belongs. Now, fellas, if this is the law, then your lordships, fellas, has to consider, and not your lordship, fellas, the persona designata exclusively constitutionally entrusted with this power is one person, the speaker. That persona designata will have to consider no one else. What you did in Surat, what you did in Guwahati, what you did outside, good, bad, or indifferent, what you did with the governor, is directly Ravi Nayak. And inference can be drawn that you gave up. Now, if you gave up, then how do you operate clause 15 on the assumption that this is one faction of the party, this is another faction of the party? So, complete conceptual contradiction is my point number 1. And that is what is happening. Your lordship may kindly read again to save time, I will not read it. The 4th of August 22 order of this honorable court. The last 4 lines, we all appeared in this, was based on a clear understanding at that time by that honorable bench that the election commission would not proceed. And the last 4 lines of that read like this. According to the learned senior counsel, that is Mr. Dada, it says so. The proceedings may take some time as voluminous evidence is usually submitted by the parties which must be considered by the EC. The learned senior counsel therefore states that no orders may need to be passed by this court interdicting proceedings before the election commission. In these circumstances, we grant liberty to the petitioner to file an application before the EC for seeking time. Such applications are filed 3 times. Time was given with consent. There is no formal order, no doubt, but this is endured from the 3rd week of July till today as we speak in October. September. That is point number 2. Point number 3 is what is the balance of convenience clearly endured for further 1 month. If this is endured already, it does not at all cause them irreversible. However, your lordships not protecting us causes us irreversible. That's point number 3. This is point number 4. This ground of IM. your lordship, because I don't think should be catered by the form of an IA versus the substance of what we are. That's the simpler answer. But two more important answers for us in law. It would be, according to me, quite quaint if your lordship said that because an IA, your lordship can't decide this matter, it's outside the scope of the arrangement. But there are two other answers, factually wrong. Number one, we find several writs, including what your lordship will call the all-encompassing writ, which is number 493 of 22 on 8th of July. Prior to that, your lordship has 4 other writs in which this order of subject to outcome has also been passed. Prior. Election Commission is a subsequent development. It's as simple as that. It's a subsequent development. My writ 493 covers almost all the issues we have argued. 1 week, 10 days after the 8th of July, when I filed the writ, on 19th of July, this election commission is initiated. I have filed an IA saying that this is a subsequent development. While your lordship is hearing the main matter, please defer it. Because is that something so startling and beyond jurisdiction, like a fundamental lack of jurisdiction, that your lordship cannot touch it? Therefore, that is, well, I hope, not their best answer. Now, Willis, one other thing, and I'm done. There is 2 paras of Rana very important. One, my learned friend Mr. Kaur read para 25. He did not read para 27, which is the following para after 1, which is very important. And the second para is 48. So these 2 paras I'll take 2 minutes on. My learned friend Mr. Paul read the sentence to be very
Para 27 and 48. There's just one more. Let me
Mr.
go to grammar.
27 is the answer to 25, so that the context is placed in 27, which follows has to be read now.
Just give us, just give a moment. Page 192, right?
Yes, so my learned friend read para 25 and he read this sentence actually, virtually the sentence alone. Para classical C. The power to recognize a separate group in parliament or assembly may rest with the speaker on the basis of the rules of business of the house. But that is different from saying that the power is available to him under the 10th schedule to the constitution, independent of a claim, mark word independent, of a claim being determined by him that a member or number of members had incurred disqualification by defection. That's a sentence Mr. Paul read. Now, the sentence which connects this is para 27 page later, where it is viewed as a continuum, as a part and parcel, and it is a continuum of split, merger, and disqualification. All are interconnected and have to decide by the speaker. Can you read that? This is para 27 from classical D for Delhi. In that context, the speaker cannot say that he will first decide whether there has been a split or merger. There are 2 concepts there. As an authority. And thereafter decide the question whether disqualification has been incurred by the members by way of a judicial adjudication sitting as a tribunal. Next sentence is crucial. It is part and parcel of his jurisdiction as a tribunal while considering a claim for disqualification of a member or members to decide the but also in the context of the raised by this person that they have not incurred split in the party or in view of a merger. It is part of one continuous process of the speaker, who's a persona designata by the constitution, no less. Now, while your lordship is on this, just let me finish on 48 of the same judgment. Also, not this great. This is just 2 lines. This is just to correct, but there's one out of hundreds of examples, myriad examples which occur in 218 of voluntarily giving up. This case involves the very specific case, the act of giving a letter requesting the governor to to call upon the leader of the other side to form a government itself would amount to an act of voluntarily giving up the membership to the party of which to get the said members and party. It is because all over the press and repeated that they went in this case with the other faction to the other party to the all admitted documents, all was on the record to the governor, doing exactly what Rana records in Paramatma. My fifth point is that your lordship is cited, I want to make a general fifth point and then tell your lordship. I am made bold to say, and I've checked with Mr. Devdas Kawat, who is very meticulous of this subject. 10 times I've told him. Not one single case. I repeat, lordship recorded my submission. It's a rather broad thing, I don't want to make the wrong case. Not one single case where the interaction and interplay between a disqualified or disqualifying pending matter in a symbols case. Not one case. I can't put it more widely than that, but I'm open to challenge on that. From that follows point number 6. One case is cited, which is Kumar, etc. 1985, 4 SCC 628. Just note the citation, I have not taken off, just note the difference. The only case cited is 1985, 4 SCC 628, where para 1 notes that this is a challenge to the constitutional validity to the government. For one. Number 2. No issue arising in that case of disqualification. Now we have the 10th schedule. What was the 10th schedule in a descriptive manner saying now we have 10 schedules, that's para 10. That one para becomes the springboard, erroneously and wrongly, of citing that case, suggesting that there is an interaction between the symbols jurisdiction and disqualification. Nothing whatsoever. It's a completely inapplicable and irrelevant citation for this subject. May I end by saying, after thanking a lot for giving us time, that if the party, if there is, why should we kindly go back to the origin? Why did the 10th schedule use 2 broad words? Actually, this intra-house issue was the whip issue normally. Of course, it can apply beyond the house also, I'm not saying, but I'm saying that was the focus. They deliberately and consciously used a very much wider concept. That concept falls directly in this issue to be decided one way or the other by the primary persona designata, the speaker's jurisdiction. It may or may not be briefly decided later on, but because the primary direct custodian of 10th schedule is only one person. As a matter of fact, there are problems sometimes speaker is disqualified. Then the persona designata, then you start going hunting for a deputy speaker, which is strictly not legal. And then nobody there at all, then your lordship perhaps will interview. So therefore, your lordships will not short circuit this process. And no other procedure exists for deciding how to give a voluntary membership of party except what is here in 218, which the speaker to his best ability decides. Today, in effect, your lordship is being asked to do 2 things by the other side. A, that this be decided first by the election commission. B,
what should be decided?
Decided first is what your lordship is told. I will let the EC decide it first. B, is the nature of what is a political party minus them or with them will be decided first, and thereafter the nature of the party will be decided by the state.
But just one submission for your lordship's kind consideration. Only on Kyoto Holo.
No, it cannot be, Mr.
That was Kyoto Holo. Mr. Rejoinder was cited. Just one second.
One sentence.
1 second. But Kyoto Holo said that while a show cause notice by a speaker is issued, no judicial review will lie till a final decision is taken. And that's why they're saying we ought not to have come at the stage when a notice was given to us on the 27th and when the order was passed. We came relying on Navam Rebia, which said the speaker cannot proceed with the matter. A constitution bench of this court had said the speaker will not initiate, continue, or proceed. So the issue was completely different, and their 32 is actually contrary to Kyoto because they are seeking this court to transfer all the jurisdiction of the speaker and decide it. And Mr. Sibbal presumes that we are disqualified and the EC today cannot be approached.
All right.
First issue.
Yes. You've heard Mr. Abel Sibal. and Dr. Abhishek Singhi, then counsel appearing on behalf of the petitioners in support of the application for stay proceedings before the Election Commission. Mr. Neeraj Kishan Paul and Mr. Maninder Singh have appeared on behalf of the private contesting parties. Mr. Tushar Mehta, then Solicitor General, has appeared on behalf of the Governor. Mr. Harun Dehtan, then Senior Counsel, has appeared on behalf of the Election Commission. Next. We've heard the. Sorry? Oh, yes, Mr. J.
What's it forgot me?
I'm so sorry.
No. Quite forget.
No, not at all.
Apologies. Having heard the Learning Council, we direct that there shall be no stay of the proceedings before the Election Commission. The IA seeking stay shall accordingly stand dismissed.
Very grateful. Extremely grateful.
Is allowed.